Good morning and welcome to our jurisprudence class. So last week we continued with discussion of legal positivism, and we discussed Hart's contribution towards legal positivism through his work, the concept of law extensively. And we made the point that what Hart sought to do was to demonstrate how, in his view, the various attempts to address the key issue in jurisprudence, the nature of law, what is law, has been unsuccessful or unsatisfactory as far as he is concerned. And among other things, Hart said that it all has to do with the fact that the various attempts, especially the National Law School, failed to separate factual existence of the law from the moral quality or the evaluative dimension of the law. And apart from the National Law School, who had blamed their failure to make progress as a result of the separability conundrum, that is failure to separate law from morality. He also had his serious doubts about the efforts by other legal positivists, such as Jeremy Bentham, Mostyn, and co., who look at law from the point of view of command, sanctions, and all that. So this morning, we want to move beyond Hart and discuss Kelsen's contribution towards legal positivism. Kelsen was an Australian-American jurist who is also associated with positivism, and he was one of those who put the Australian Constitution together. He became a judge of the Australian Supreme Constitutional Court after he had left the US. Now, the most important thing as far as Kelsen's contribution to legal positivism is concerned is a work that he did. The work, you call it the general theory of law, and he will advance what we call the pure theory of law. And look at his description, pure theory. So the use of the qualifier pure should immediately tell you something, that this scholar or this proponent of legal positivism is on a certain trajectory, a certain mission, and the mission, please, just a minute. Let's Yeah, so I was making the point that if you look at the use of the word pure, pure theory of law, that is presupposition that the theories of law which predated him or which had been propounded before he came onto the scene, in his view, contain a lot of impurities, contain other things which are not supposed to be taken into consideration and propounding theories about the law. And that is why he sought to distinguish his efforts from efforts of others. And then he would say that, okay, mine is pure theory of law. So his object is to assist in the understanding of positive law in general and not of any particular legal order. He sought to explain what the law is and not what the law ought to be. So right away, that tells us he's not a natural lawyer. Natural law, they are concerned about how the law ought to be. He sought to explain what the law is. So that is making him quintessentially legal positivist. And commentators will point out, sought to contribute to science of law and not to legal politics. And of course, its own writing. If you look at the choice of the name, pure theory, just like, if you like pure science. So that he's interested in looking at the science of law and not the politics around law. So as a theory, Kelsen's sole purpose is to know its subject, to know the subject of law. So that is what he sought to do. And he seeks to make a rigorous inquiry based upon a strict methodology which enables him to ignore certain extraneous or irrelevant matters which previously had been taken into account by others that propounded some theory. So Kelsen aimed to construct a pure science. Of course, we put the pure in inverted commas, a pure science of law grounded in positive philosophy. So unlike earlier positivists like John Austin, Kelsen's work sought to establish a system where law could be studied independently of external influences, such as political ideologies or moral beliefs. And this also would set him apart from what American scholars, those who follow the schools of thought we call legal realism, will also tell us. Later on, when we are learning legal realism, especially American legal realism, we will be told that to understand law, we should not decouple decisions of judges from their backgrounds, from their beliefs, from their orientations, and all that. And all those things are important in influencing how judges think about law, and so on. Now, Kelsen's view is that law should be looked at independently of any ideological, political, or moral beliefs or convictions, as it were. So Kelsen's approach is designed to make legal analysis strictly objective. And he sought to emphasize that law should be understood purely on its own system, on its own terms. You are understanding law on its own terms and not in relation to other things. So you don't need to understand law in relation to economics or to sociology or to politics or to religion or any other thing. Just so, as you will notice, this is later on, if you look at the legal research methodology, this is purely black letter law, or if you like, a doctrinal legal approach. So according to Kelsen, for you to achieve what he is setting himself up for, it will require a methodology that excludes subjective values and focuses solely on legal norms. So we look at only what you call legal norms, ignore any subjective consideration. So that way, we can say that Kelsen's theory he sought to advance is founded on the notion that law is a normative system. Law is a normative system. That is a system of norms that prescribe behavior. So system of norms that prescribe behavior. And that is why he is saying that law is a normative system. And these norms in Kelsen'ine thinking are not simply commands or expressions of will, but are abstract prescriptions that carry a unique legal force. So, for example, policeman would stop your car. Why is he stopping your car? Because of a certain norm, which requires that he has to make sure that cars either drive at a certain speed or they respect certain light indications, what they call traffic light on the road, as it were. So, considered from this introductory perspective, Kelsen's pure theory of law stands out in jurisprudence for its rigorous attempt to separate legal science from other forms of normative analysis, specifically morality and ethics. So the fact that he is looking at law as a normative system should not let us make a mistake of thinking that then Kelsen has actually come back to the reign or the territory of the natural laws. Not at all. So, yes, he has said his law is a normative system, and that the work of the jurists should be about investigation of the legal norms. So, how does Kelsen understand legal norms? So, what is Kelsen's concept of legal norms? In Kelsen's thinking, a norm is understood as a rule that prescribes certain behaviors. So rule which prescribes certain behaviors, like the example that I gave to you. Probably like we have like the traffic regulation or the traffic code, which says that drivers should drive in a certain way. If they don't drive in that way, then the policeman is supposed to take certain steps or actions. So norm is a rule that prescribes certain behavior. And legal norms, unlike moral norm or social norms, derive their authority from their position within a formal legal system. So, validity is very important. Whatever you are claiming to be a norm, what is the source of this validity? What is its place within the formal setup or the formal establishment of the legal system? So Kelsen was interested primarily in understanding the structural elements that give norms their binding nature. What makes norms binding? And Kelsen argued that the validity of a legal norm is not based on its moral or social value, but on its relationship to other norms within the system. And later on, he'll talk about some kind of like a succession of norms. or chain arrangement of norms, so that each norm derives its validity from the immediately preceding norm, as it were. So for Kelsen, law consists of a hierarchy of systems, each deriving its authority from a higher norm. So you have the norms arranged, right? Arranged either in ascending or descending order. And each norm derives its authority from a higher norm. So later on, I have endeavored to construct a figure, which is an attempt to have a diagrammatic representation of what Kelsen is telling us. I have like the pyramid, and which tries to illustrate that each norm derives its authority from a higher norm. So this chain of validity, that is each norm deriving its authority or validity from a higher norm, ensures that each legal rule is connected to an ultimate foundational norm, a basic norm, which Kelsen calls the Grundnorm. So look at the spelling, it's not the ground norm, the Grundnorm. So if you want to know why the policeman stopped the car, you point to the fact that yes, there's a motor traffic regulation which says that when a certain situation exists, the policeman can take a certain enforcement action. Okay, then you move on. What is the source of authority of that regulation? Then you may want to say that Parliament made the Road Act or something, and out of that, the minister has made the regulations. Then you want to ask, what is the source of authority of that Act of Parliament? That Parliament is the authority or the body which is charged with making laws in Ghana. Then you ask, how did that come about? Then you trace it. So you keep tracing the source of validity of each norm in a successive order, in a chain-like order. And as you do that, you will get to an end, and it will take you to like the ultimate, the overall source of validity, what you call it, the Grundnorm. So understood that way, Kelsen's view of law can be seen as a normative pyramid, like a pyramid of norms. Pyramid, just like a bit like the triangle, with the Grundnorm at its apex, serving as the ultimate source of validity for all subordinate legal rules. Or you can look at it also from reverse, either inverted the pyramid, especially when it tries to explain the legal effect of coup d'etat, the legal effect of coup d'etat on the pre-existing legal order. Yes, Agogo. Oh, sorry, Gogo. I used to previously have a Gogo. Yes, Gogo.
Good morning.
Morning.
Please, I just wanted to find out from your explanation you just gave. Can we then say that the Grundnorm will get confusion when it comes to that?
Okay. You hold on. We'll get there very soon. Yes. We'll get there very soon. That's the next slide. So we have said that Kelsen introduced the idea of a pyramid of norms, like the norms are arranged in hierarchical order. And in that hierarchical order, every non-validity depends on its relationship to a higher norm within a chain of norms. So maybe if you are to visualize it, do something like this, but I've decided to invert the pyramid instead of letting the pace here go up. I just chose to let it be the other way around. So here is the base or the apex. If you turn it the other way around, so highlight the Grundnorm here. So this Grundnorm gives effect to the next norm, the constitutional norm, and then the legislative norm, administrative norms like regulations and the rest, and then judicial norms. So within this, each norm is deriving effect from the preceding norm, so to speak. So the Grundnorm, as we have said, is the ultimate foundational norm that forms the basis of a legal system. And all other norms derive their validity from this Grundnorm. And in talking about this, I'm sure the case of Salavis Attorney General rings a bell. The case of Mazimabuto against Lagnabek rings a bell. The case of Espat Motovo rings a bell. The case of DPP Mashe rings a bell. The case of Lakami from Nigeria rings a bell, in which they attempted to appeal to some aspect of Kelsen'S thinking in order to state the effect of coup d'etat, unconstitutional change in government on the pre-existing constitutional order. So we also have the constitutional norms. So norms at the level immediately below the Grundnorm, so such as the country's constitution. So this provides, so Mr. Agogo's question. So the constitutional norm will come after the Grundnorm, and the constitutional norm provides authority for creating other laws within the legal system. So if you take Ghana's constitution, for example, yes, you look at Article 1, Clause 2, Article 2, Article 11, the laws of Ghana and all, and you look at the Article 93, Article 106, the power of Parliament to make laws. So all those things are derived from the Constitution. But the Constitution itself also has its source of validity. So that is like the Grundnorm. The Grundnorm. And then after the Constitution, you have like the legislative norms, laws passed by legislative bodies like Act of Parliament and so on. And we also have administrative norms immediately after the legislative norms. So rules and regulation, delegated legislation, subsidiary legislation made by governmental agencies, which derive their authority from legislative norms. And after administrative norms, Kelsen also identified judicial norms, judicial decisions and case law that interpret and apply legislative norms and fill gaps and resolve ambiguities. So that is the pictorial view of Kelsen'S hierarchy of norms. So in this hierarchical order, each norm is connected to a higher norm from which it derives its authority. So a statute, as I illustrated, derives its authority from the Constitution. The Constitution itself derives its authority from the Grundnorm. And to Kelsen'S mind, this structured hierarchy is essential to ensure that legal system functions as a coherent, unified entity And that is why he said that law can be studied on its own terms and not in relation to non-legal matters, extraneous matters, like political dimension, sociological things, religious, and so on. So let's say a few words about the Grundnorm, also known as the basic norm. The Grundnorm, or the basic norm, is a central concept of Kelsen'S theory, in the sense that it is a foundation upon which the legal system is built. The Grundnorm is not a written law, so let us get that clear. The Grundnorm is not a written law necessarily, or explicit command. Rather, it is a presupposed norm that provides the basis for validity of all other norms within the system. So the existence of the Grundnorm is presupposition. So it is, if you read the Kelsen'S original work, you see that it is the historically first constitution. We don't know exactly when it started, and it's not necessarily about any particular document, as it were. So it is a hypothetical norm accepted by society as a foundation of legal validity. So probably, of course, I'm not saying that Kelsen used the social contractarian approach, but just as if we move away from Kelsen and we wanted to get some maybe analogy, you know how social contractarians, for example, cannot tell us when the social contract was made. So in the same vein, this Grundnorm, this basic norm, which is supposed to be the source of validity to all other norms within the legal system, are imagined to have existed long ago. So they are presupposed. They are presupposed. Their existence is taken for what? Is taken for granted. So the Grundnorm serves as the ultimate criterion of legality within a particular system. So the Grundnorm, in that case, is so necessary in ensuring a stopping point in the chain of validity. So if you are trying to trace, let me give you let's take another example. So let's say another example, you get a piece of land, you build on it, and the city authorities will come and write on it, stop work, produce permits. Now here is the case: you bought your land, you've done all the necessary things. Now city authorities come and say that stop work, produce building permits. So question is, what is the source of authority on basis of which the city authorities are saying that produce a building permit? You probably point to either the building regulations made under the old Local Government Act or some other legislation. Okay, then you ask, what is the source of validity of the building regulations which enable the city authorities to demand that you should produce your building permit and to take you to the Local Governance Act? What gives authority to the Local Governance Act? It takes you to Parliament. What gives power to Parliament to make the Local Governance Act? You go to the 1992 Constitution. What gives validity to the 1992 Constitution that they can empower Parliament to make law? So you trace it that way and you get to that ultimate norm, the Grundnorm, which will provide the stopping point in the chain of what? Of validity. So without the Grundnorm, Kelsen argues legal norms will lack a definitive source of authority, and this will lead to endless regress in search for legitimacy. So the Grundnorm is really important. So if we take constitutional democracy like ours, and probably Regina, the Google may be happy with this suggestion that the Grundnorm might be the principle that the constitution is the supreme law of the land. But of course, as I said, this is not exactly what Kelsen'S said, except that if you take the substance or the essence of its reasoning and you look at the reality of how constitutional democracies are, we could probably say that, like in Ghana, for example, how we've explained that probably is the 1992 constitution like the Grundnorm. But if we say the 1992 constitution is the Grundnorm, the 1992 constitution is also not dependent upon another norm for validity. It just assume validity on its own. So that is the complexity. But otherwise, it will fit the picture because all subsequent laws, if you go to Article 11, all subsequent laws derive their validity from the Constitution. And especially so, when we take existing law, I think under, if we take Article 11, I think clause 5 or so, the existing law where we are told that, let me read Article 11, clause 5. Yeah. So subject to provisions of this Constitution, the existing law shall not be affected by coming to force of this Constitution. Then says, we'll make the point, clause 6, 11 says, the existing law shall be construed with any modification, adaptation, qualification, exception necessary to bring it into conformity with the provisions of this Constitution or otherwise to give effect to or enable effect to be given to any changes effected by the Constitution. So the existing law, as we know, refers to the laws which were enforced in Ghana before 7 January 1993. And we are told that, yes, for it to continue to be part of the corpus of the laws of Ghana, it must agree with the letter and spirit of the Constitution. Good. There's somebody's hand or up. Francis?
My Lord, please, good morning.
Good morning, Francis.
My Lord, please, respectfully, I wanted to ask with the Grundnorm issue in relation to the 1990 Constitution.
Right.
So, in view of that, can I say that Article 1.1, that is the sovereignty of Ghana resides in the people? I mean, that provision, can it be also classified as the validity of the Constitution, which being like the Grundnorm, in my view?
So how did we get the statement that the sovereignty resides in the people of Ghana? From the Constitution itself, isn't it? Francis, I think it's from the Constitution, isn't it? Are you there? Okay, Francis is gone. Francis, let me release you. Yes. Francis, you can, yes.
Yes, please. Yes.
So,
that
so
that provision is coming from Article 1. Sorry.
Well, yeah. So from the Constitution itself. So, if we are going by that reasoning, so the question will be that if the statement Article 1.1 is from the Constitution itself, how did the Constitution assume validity? So, what is the source of validity of the Constitution? Is it the referendum that we had? Is it the PNDC law? Is it 2.8 something, which was actually signed to bring the results of the referendum into effect? So those are some of the questions we need to ponder. We cannot actually reach a resolution here, but I charge you to keep thinking about it. And that is the beauty of jurisprudential inquiry. A lot of issues are not settled, and they are still in the realm of contention, contestation, disputation. So depending upon how you want to reason your position, then we listen to it. And once we listen to it, we endeavor to try and refute your arguments. If your arguments appear to be irrefutable, then you may be persuaded to side with you. Yeah, so Kelsen'S theory emphasizes that the validity of a legal norm is independent of its content. And that is important. So as to whether a legal norm is valid or not is regardless of its content. And of course, and this is consistent with what legal positivists generally say, isn't it? That the validity of a law is a separate matter from its content, as whether it is moral or not, that it is just or unjust. And Hart, in its concept of law we saw last week, argue what they call the separability thesis, that we should separate law from what? From morality. So in a similar vein, Kelsen is saying that as whether a legal norm is valid or not is a matter which is entirely independent of what the legal norm says. What it says doesn't matter. Whether it is saying is good or bad, whether it is just or unjust. Now, on the contrary, a norm's validity in Kelsen'ine thinking depends solely on its place within the hierarchical structure. So, because he sought to establish what we call value-free science of law, a science of law which is pure, a science of law which studies law on its own terms. So legal validity is purely a matter of formal validity and not moral content. So just like the examples that I gave, for example, fire brigade or the fire service, they are coming, and once they are on the fire call and they are blowing their siren and all that, they have the power to drive anyhow and get to the place of the fire. So you put something, you put your gold or you put your bicycle on the road, and the fire car or fire tender drove through it and destroyed it. Now, the source of authority of the fire brigade is maybe the regulations or the legislation setting the map. They want to ask, what is the source of authority of those who made that legislation? And maybe it takes you back to either the Constitution or some other legislation. And what is the authority of that which gave that authority? Yeah, so that is why Kelsen is saying that as whether a legal norm is valid is the source of validity of that norm and not what it says. So where you can trace its validity to, that is what important and not what the norms are saying. So in that respect, Kelsen will say that norms are valid when they conform to the procedures and authorities outlined by higher norms in the hierarchy. So if the procedures are stated by the higher norm regarding how certain things should be done are followed, then that particular subsequent norm obtains validity from the anterior or the preceding norm, as it were. So, for example, Act of Parliament, somebody is challenging it, or what? We go to Article 106 of the Constitution. We look at the standing orders of Parliament and all other relevant procedural framework for making an Act of Parliament. If the Act of Parliament went through the full cycle of that, then it has validity. It doesn't matter what the Act of Parliament actually enacted, whether it is good or bad, whether it is just or unjust. That is beside the matter. So therefore, a law prohibiting theft or stealing is not valid because it aligns with moral principles. It's not because, yes, especially if you are a Muslim or you are a Christian or even traditionalist, you know that religiously speaking, it's not good to steal. It's not good to take something that belongs to another without the person's permission, isn't it? Good. And then, so you see a law which says that it is an offense to commit the theft or to commit stealing. Let me say that, oh, yes, this law must be valid because this law coincides with what morality teaches us. No. Kelsen is saying that way we are making a big mistake. The law prohibiting theft is not valid just because it aligns with moral principles, but because it adheres to the constitutionally defined legislative procedures that grant it authority. So if in Ghana, for example, if Parliament has made a law regarding maybe causing financial loss or a law defrauding by false pretenses or anything, or even a law about rape and all that, it's not because those laws by their content are advancing moral values. That is why they are valid. No. In Kelsen's thinking, did they follow the procedure for making law, for making Act of Parliament? So if we are talking about our country, Ghana, we know the procedure as per the constitutional provisions, Article 106, among other things. And then standing orders of Parliament, they did follow all that. If it did, then the law is valid. So we will appreciate that Kelsen's approach requires that we view law as a self-contained system where validity is determined solely by the legal structure, not by extra legal considerations. It's a self-contained system, just like some scholars like Habermas and then Tubman, they have this formal approach to study of called the autopoiesis. Maybe autopoiesis is similar to what Kelsen is saying, that you study law as a self-contained system. Don't go outside law to understand law. Later on, sociological jurisprudence will tell us to understand law, you have to understand the societal context within which the law was made. Or historical jurisprudence will tell us you have to understand the historical journey or trajectory of the particular society before you can understand law. Then we have some people called the law and economic scholars. That to understand law, you have to understand the economic efficiency dimension of various rules and legal institutions. Now, Kelsen is saying that all those things are not part of the science of law. You have to study law on its own terms and not in relation to any other. Does Kelsen also see law as a coercive order? Well, Kelsen acknowledges that law is distinct from other normatives, the ones we have seen, because it is typically associated with coercion. Force is part of law. That is what Kelsen is telling us. So coercive order, that is force. Is force part of law? Yes. So Kelsen described law as a coercive order where norms are backed by potential sanctions or consequences. And this differentiates legal norms from moral or social norms, which lack coercive force. But Kelsen points out that the presence of coercion per se does not define law. So unlike Jeremy Bentham, John Lawson, who will talk about law is the command of the sovereign backed by sanctions, and they practically equate law to commands plus coercion. Now, Kelsen is saying that the mere fact that you have coercion per se does not evidences the existence of law. Rather, coercion is a characteristic that many, but not all legal systems employ to enforce compliance. So that's the point he's trying to say. So yes, coercion is a means of ensuring compliance, as it were, but we shouldn't just take coercion alone as a definition of law. Now, in Kelsen thinking, what makes a system of norms a legal system is not coercion itself, but the existence of a structured hierarchy validated by the Grundnorm. So if you have a structured hierarchy, like each norm deriving its authority from the preceding or the successive norm, then you have a legal system. So you should also be thinking of what Hart said. Hart said that in his view, the legal system is the union of primary and secondary rules. And part of the secondary rules is a rule of recognition. So I would like you to compare and contrast Hart's rule of recognition with Kelsen's Grundnorm. So no doubt, Kelsen does not say that positive law is not important. Just like various legal positivisms, he also see positive law as really important. But all that is caution is that in studying law, we might be scientific about it. And being scientific about study of law means that we must analyze the actual content and structure of the legal norms. And we shouldn't resort to subjective moral judgments. And for that matter, positive law will be understood by Kelsen to be a law created by human authority within a specific system. And its validity is determined by its relationship to the Grundnorm. So that is his understanding of positive law. And as we have said, it's the compliance of the making of positive law with procedural requirements, like the various procedures laid down, which will give validity to it and not the moral content as it were. So at this stage, we need not be told that Kelsen rejects natural law theory. for obvious reason. And his rejection of natural law theory can be appreciated because, as we know, natural law school has said that law must be grounded in moral or ethical principles. But Kelsen will argue a contrario that natural law introduces subjective values into legal science and makes it impossible to study law objectively. And for that matter, Kelsen thinks that natural law undermines legal stability as it allows moral arguments to challenge the legitimacy of what? Of legal norms. For example, natural law will be told an unjust law is not law. If the law, let's take Ghana, for example. Let's take even this issue of the Galamsey, okay? Of course, we don't have the facts, but we don't know whether those who are doing the mining in our communities, in which river bodies and other natural things within the environment are destroyed, do they have concession? Have they been given approval by the state through its various organs or bodies to actually mine? If it is the case that they have been given authority like concession under the relevant law made by Parliament, then the next question is, did the concession and the relevant authorization prescribe environmentally friendly and safe practices which should be followed so as not to endanger the environment for present and future generations? If the lawmakers did not do that, and then they just gave them just the authorization just to go there and mine, then the law which they made in Kelsen'S thinking is a valid legal norm. But if you subject it to natural law thinking, then you say that it's morally questionable. Because how can you give authorization to someone to exploit from natural resources without ensuring that he or she will safeguard the environment and not create significant danger for other stakeholders in the environment? So Kelsen'S theory, just like various legal theories that we know, are not immune from criticism, meaning that they are not sacrosanct. They have their shortcomings and imperfections. So what are some of the key criticism? One is the overemphasis on formal validity. So some commentators or scholars argue that Kelsen'S focus on formal validity ignores the practical realities of how laws operate within society. And that is true. If you look at how law operates within society, we even have discretion, okay? We have discretion. And if you look at Article 296 of the Constitution, which is supposed to be like our highest law, it recognizes the necessity of what? Discretionary power. And so after providing so many things, the Constitution, you go to Article 296. Somebody should read Article 296 for us. Who is reading? You don't even have your Constitution. Okay. Okay, James, go. James?
Article 216, exercise of discretionary power. Where in this Constitution or in any other law, discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And C, where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of the discretionary power.
Okay. Yeah, so please also read the residual powers of Parliament for Article 298.
Article 298. Subject to the provisions of Chapter 25 of this Constitution, where on any matter, whether arising out of this Constitution or otherwise, there is no provision, express or by necessary implication, of this Constitution which deals with the matter that has arisen, Parliament shall, by an act of Parliament, not being inconsistent with any provision of this Constitution, provide for that matter to be dealt with.
Okay, good. Now, if you look at our Article 296 on discretionary power, the framers of the Constitution, after providing for so many things, recognize that you cannot reduce everything into explicit rules, and there will still be many areas in which officials, public officials, will have to exercise their subjective judgment in one way or the other. And where a public official endowed with discretion is not like a judicial, is not exercising judicial power, then that public official is supposed to come out with some kind of rules which will tell the public how the discretionary power will be exercised. But that is supposed to be in accordance with the Constitution. Now, if you take the Constitution, there are various things, especially Chapter 5, Fundamental Human Rights and Freedoms, Chapter 6, Directive Principles of State Policy. So where an official has, for example, issued regulation to govern how he will exercise discretionary power, if same undermines the Constitution, especially, let's say, the Fundamental Human Rights, Directive Principles of State Policy and all that, despite the fact that the authority, the public official will have used the procedure prescribed, what the public official has done will still not be constitutional. And this is where Kelsen'S theory will run into problem. And that is why some scholars say that he places unnecessary, too much emphasis on formal validity, but he ignores the actual operations of law within society. again, if you look at Kelsen, his theory is also detached from social realities. If you look at everyday application of law, where judges, lawmakers, and citizens consider social factors, policy implications, and ethical concerns before taking one step or another in relation to law, then there's a problem with Kelsen. You look at even the courts, right? The courts sees with various matters, will sometimes be mindful of also implications of the case before them on society or public interest and all that. And that is why, for example, if you take Supreme Court, there are some cases they will even like the cameras to be brought to the court for everybody to hear and know what is going on, because the courts are aware that such cases have huge public interest implication. So it's not just a matter of they have the jurisdiction or the power. So they just sit in the corner and come out with the decision, and no, they want people to follow the process so that they will appreciate the outcomes, as it were. There's also a problem with the Grundnorm. That's another area of criticism. The Grundnorm has been criticized for being vague and overly theoretical, steeped in deep abstraction. And some critics argue that the Grundnorm is an artificial construct that fails to account for the dynamic and evolving nature of legal system. And that is true, especially if you take, let's say, Ghana, where we've had a checkered political and governance history. We've had times that constitutional arrangements are interfered with or dislodged by the men on horseback, the military. And we live with them for some time. And after a while, they'll say that, okay, you want to go back to barracks and allow you people to govern yourself. So you have another constitution which is adopted. So if you look at all these dynamics, how can you actually support the view that we have like a Grundnorm? Which one is a Grundnorm? If the Grundnorm is historically presupposed first constitution, so what happens? And especially you, Kelsen, yourself, you tell us that when there's a revolution or coup d'etat, your famous theory of discontinuity, that it blows away the Grundnorm, and the coup makers, if they're able to effectively establish the authority, and the authority is by and large accepted by the people, there's no efficacy, then they will be like, if you like, the new Grundnorm. So if that is so, how do we even support your Grundnorm, which is essential component of your theory of law? And again, Kelsen has also been criticized for excluding morality. That is, his theory does not make room for any moral consideration. And that has been criticized as being dangerous because it can potentially encourage giving legitimacy to unjust laws. Because after all that matters is that the unjust laws complied with the procedures for making law, and once the procedures are complied with, so be it, regardless of the content or the outcome. So critics are concerned that Kelsen's approach could allow immoral laws to persist as long as they conform to the hierarchical structure. And in fact, if you look at what happens in Nazi Germany, Adolf Hitler's regime, he ruled according to laws and all that, and all the wicked policy of trying to destroy group of people, the Jews, the Holocaust and all that, all these wicked policies were as a result of law which were passed. So if you are saying that all that matters is the procedure for making law have been followed, you are going to run into what? You're going to run into a problem of allowing immoral laws and just law to persist. Yes, regardless of the shortcomings of Kelsen's theory, it is also true that Kelsen's theory has some practical applications in constitutional and international law, especially if we look at the doctrine of supremacy of the Constitution. Despite the imperfection, we could say that the doctrine of constitutional supremacy somehow is an application of the role of the Grundnorm in Kelsen's thinking, or if not even the Grundnorm, his idea that of the hierarchical or the structured approach of legal norms within the legal system, because the Constitution will say that all other laws must agree with it. Yes, so that is an aspect of Kelsen's thinking, that legal norms should derive their validity from preceding norms or other norms within the chain of validity. And when you're also trying to reflect on the effect of unconstitutional changes in government, right, coup d'etat, revolutions, on what happens to the legal order or the legal system which existed before the coup d'etat. Some people have also found Kelsen's thinking useful. So if we look at some places which have experienced coup d'etat or revolutions, you go to Uganda, for example, the case of ex-party Matovu, you notice that the court followed Kelsen's thinking that coup d'etat actually has the effect of destroying the pre-existing legal order. And then, if you come to our own country, you notice that Kelsen's theory of discontinuity was rejected in the famous case of Salah versus Attorney General. Now, those who are interested in deepening their knowledge, of course, this is a constitutional law, their knowledge on the effect of coup d'etat on pre-constitutional order, especially what Kelsen says. I have a lecture I gave to constitutional law students. I will make that available to you on your platform so that you can play it back and refresh your memory, and also let it help you in this area of jurisprudence. Now, when it comes to international law, Kelsen's theory has influenced development of supranational legal system. When we say supranational legal system, we are talking about where treaties and conventions form a hierarchy of norms binding on member states. So, in Kelsen's thinking, the international legal order is one, and is not separate from the municipal legal order. And his thinking also reflects, the monism, if you remember, the relationship between international law and municipal law, monism and dualism. For dualists, the view is that when a law is passed, the law will need to be domesticated. Now, the monist holds the view that once a state has signed up to a treaty on the international plane, then it assumes the bindingness within even your municipal system as well. Yeah, so we will take your questions before we start discussion of Dworkin's legal theory.